It's good morning. We are on the record in the 53rd Circuit Court for the County of Sheboygan. We are providing public access both in the courtroom and also online. We have next the case of People v. Michaela Strimick. It's two file numbers, 25-6975FH for probation violation matter and 26-7131FH for, looks like, an arraignment and a bond violation matter. Counsel, you want to state your appearances, please, beginning with People?
Melissa Goodrich, Sheboygan County Prosecutor.
Morning, may please Honorable Court Kareem Johnson, P number 71988, appearing on behalf of Mr. Strimick.
Good morning, Mr. Johnson. All right, so we have an arraignment in 7131, so we should probably get that taken care of here. Have you had a chance to review the charging document with your client?
Not the information. No, I have not.
Okay. Ms. Strimick, it's alleged that you, in file 26-7131, it alleges that on or about October 20th of 2025, in the state of Michigan and county of Sheboygan, that you did knowingly or intentionally possess methamphetamine. That's a felony punishable by up to 10 years and or $15,000 fine. However, the people have filed a second or subsequent offense notice, commonly known as a drug double, alleging that you have prior convictions for violations of drug cases in 2015, 2019, and 2020. That would make the penalty in the court's discretion doubled, so 20 years and or $30,000 fine. The people have also filed a habitual fourth notice, alleging that you've been convicted of 3 or more felonies or attempts to commit felonies from 2015, a delivery, 2019, an attempt harboring felons, 2019, a delivery, 2020, a delivery, 2025, a prisoner possessing contraband, 2025, an absconding bond. With that habitual notice, in the court's discretion, the penalty would be life. Would be the maximum penalty that...
Before we dive in, just a quick note. This commentary is created for educational purposes, designed to help those who may be confused or curious about courtroom processes. If you don't find it helpful, feel free to skip ahead. But for those who want a deeper understanding, stay tuned. It's about to get intense. Right out of the gate, this case escalates fast. Prosecutors aren't just alleging simple possession. They're stacking prior drug convictions, a habitual offender enhancement, and even the possibility of a life maximum penalty. That's a massive legal threat hanging over this defendant before the real battle even begins. And now the court is weighing not only the new meth charge, but whether multiple pending cases and probation violations show a pattern the judge can no longer ignore. The pressure in this courtroom just went from serious to potentially life-changing.
You would face on that charge. Mr. Strimick, do you understand the charge against you in that file?
I do.
Okay, Mr. Johnson, how she wish to plead to that charge?
Yeah, at this time, we asked the court to, for a not guilty plea.
Okay, we'll enter a not guilty plea on that charge. And is a forensic center referral requested?
Yes, Your Honor.
Okay, as to competency or criminal responsibility or both?
Well, Your Honor, I guess technically one will be requested on a case that is in district court. I have no concerns about competency or criminal responsibility for this matter. The prosecution and I have worked out a resolution that encompasses this case and all open cases. It does not resolve the case that is at district court. So I guess I haven't specifically talked with Ms. Goodrich as to whether or not that offer is still open for these cases, but there is an outstanding case that we need to deal with.
Okay, so you're not requesting me to enter any orders for referral to the forensic center at this time in this file?
No, Your Honor.
Okay, I'll indicate that that's reserved at this time. So what we have right now is we've got to set a docket call in this case and a bond violation hearing, and I think that is based upon new alleged criminal activity. And is that the district court case, Ms. Goodrich?
Yes.
Okay. And we also had she's on probation in the 6975 file. And the possession charge I just arraigned her on is the basis for that probation violation. So should we set both these cases out for a docket call and review of the bond and probation matters then, and give you time to sort that out with Ms. Goodrich, Mr. Johnson?
Yes, Your Honor, please.
Okay. I could put it on, April 28th at 10:30 a.m. I would allow a Zoom appearance if that's more appropriate for you that day, Mr. Johnson. You're always welcome in the courtroom, though, if you wish.
Yes, sir.
And we'll set that for a docket call and also a status conference on the pending bond violations at the same time. And we'll also set that for a status conference for the probation violation in 6975 at the same time as well. Is there anything further on this file from the defense, Mr. Johnson?
Yes, Your Honor, I'd like to address my client's bond.
Okay, go ahead, sir.
Got it. In terms of the new case, that was the bond violation and a second probation violation, I have looked at the accusations in that case. I am currently in a homicide trial. We're on break today. And in preparation for that trial, I have not been able to do or complete my legal research. That case involves a home in which my client had an ownership interest in. The ownership was being transferred, and in the midst of that, the home was destroyed. I have not seen the transfer of ownership paperwork or any contract, but at this point, I haven't been able to counsel my client as to whether or not I do believe an actual crime occurred if property that she owned was in fact destroyed at her consent, because I don't think she's alleged to be the person to destroy it. She's also, I believe, currently right now dealing with a high-risk pregnancy. I know that she was taken to a mental health institution by the county jail. I do not know if she had any illegal substances in her system during that time frame. And I will be starting another homicide trial the second week of April that I do believe should be done by the 28th. So, my schedule for the next, month or so, I have 3 capital cases, Your Honor. I do not believe that my client is a flight risk. She calls me repeatedly when she is out to check in on her court dates. I know she calls the asylum counsel office there repeatedly. She's reached out to me from the county jail. So I don't think she's a flight risk. I'd ask the court to consider releasing her on a nominal bond while, we litigate these issues, Your Honor.
Thank you. Ms. Goodrich, people's position.
Your Honor, we just had Ms. Strivick on in a absconding case, it looks like in 2025. Now we have a couple probation violations, and she's been out in a bond violation. 2 new cases, and she's been on probation in those 2025 cases. For those reasons, I would ask that her bond remain revoked.
Yeah, I don't want to, I guess I don't have any jurisdiction to address a case that's not even in front of me anyway. And so I'm not sure we want to litigate that case right now, but it is true that you can't be convicted of destroying your own property. The issue that Mr. Johnson raised, is that an issue you're aware of and have looked at and are believe you've got valid charges nonetheless?
Your Honor, Mr. Juliet was handling that case.
Okay.
He was the property attorneys.
Okay. All right. Well, I guess, we've had Ms. Strivick on probation here, and then she's alleged to have violated her probation by criminal charges, and she's got these criminal charges. And I commonly, I always consider that at that point, whether someone on probation alleged to be committing new felonies should be held without release or be released on bond. And I did release Ms. Strivick on bond for the probation violation. But then while that was pending, she's caught a second felony case. And I understand Mr. Johnson's indicated there may well be a legal defense of that case. He believes legal or factual defense. But I've still got somebody on probation that now has accumulated not one, but two separate felony charges, separate felony cases. At this point, I'm going to continue to have her held without.
This is one of those moments where courtroom strategy and real-life consequences collide hard. The defense is arguing that the new property-related allegations may not even legally qualify as a crime because of ownership issues, but the judge isn't focusing only on that single accusation. Instead, he's looking at the bigger picture, repeated felony allegations while already on probation. And that's critical. In probation hearings, judges often care less about winning technical arguments in the moment and more about whether the defendant appears to be spiraling deeper into criminal behavior. What do you think? Should the court give someone another chance while questions still exist about the evidence? Or does public safety have to come first?
Release till further order of the court. Mr. Johnson, if there's any change in the legal status of the district court matter, of course, that might affect my thinking. So, please let us know. And if you need to file a motion to have it heard, before the 28th or something, you certainly are free to contact our court to do that. Okay.
Yes, Your Honor. Thank you.
Okay. Thank you. Well, that'll conclude our matter this morning. We'll be in recess. All right. Good morning. We're on the record in the Third Circuit Court for the County of Sheboygan, and we are providing public access both in the courtroom and also online. We have an arraignment on a bench warrant. It's People of the State of Michigan versus Jeremy Oliver Baker. It's two file numbers, 24-6923FH and 6924FH. Counsel, you want to state your appearances beginning with People?
Melissa Fitters, Flint County Prosecutor.
And good afternoon, or good morning, Your Honor. James Gilbert acting as the MIDC arraignment attorney.
All right. And Mr. Baker, it's alleged that you are in violation of your probation in both these files. It's the same allegations in each file. It alleges 3 counts. They are what's called non-technical probation violations. It alleges in count 1 that you violated your probation by breaking the law, and that on or about June 26th of last year, you did deliver the controlled substance Suboxone. Count 2 is violation of probation by breaking the law, that on or about June 30th, you delivered controlled substance Suboxone. And count 3, that you violated your probation by breaking the law, that it's alleged that on or about July 7th of last year, you did deliver the controlled substance Suboxone. You have the right to have a hearing on those allegations, where they would need to be proven by a preponderance of the evidence. The rules of evidence don't apply at any such hearing except as to privilege, but you do have the right to an attorney at public expense if you qualify and request, and you do have the right to present evidence in your own defense, to cross-examine any of the witnesses that are presented against you. If you are found to be in violation of your probation, I could revoke that probation and sentence you on the underlying offense. And it looks like in file 6923, you're on probation for possession of methamphetamine, the 10-year maximum. Resisting obstructing police, a 2-year maximum, discretionary consecutive, and escape from lawful custody, a 1-year misdemeanor. And in file 6924, stalking, a 1-year misdemeanor. So with the discretionary consecutive sentencing, the maximum penalty that you could face if your probation is revoked would be 12 years in prison. Do you understand the rights that you have and the maximum penalties involved, Mr. Baker? And Mr. Gilbert, do you know how he wishes to proceed?
Yes, Your Honor. He wishes to plead guilty to the violations.
Has there been a charge in another county?
There has, Your Honor, and was already applied in that county.
Okay. Has he been sentenced in that county?
Yes, now.
Okay. What county was that in?
That'd be Mackinac.
Do you know when his sentencing date is?
I believe the probation officer said it was like the 21st. 14th. 14th. Okay.
Okay. Mr. Baker, as best you can, would you raise your right hand for me? You swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, you put your hand down. Mr. Baker, has anybody promised you anything in exchange for your plea?
Also.
Has anybody threatened you in any way? Is it your own free choice to enter that plea? And when you entered the plea up in Mackinac County, I imagine you were advised and knew that that could well violate your probation in this county?
Yes.
So are you on probation in this county from, it's like April of 2025 in both these files? Okay. And and then while you were on probation, did you deliver the controlled substance Suboxone?
Yes, sir.
Okay. And was that in June 26, 2025?
Yes, sir.
June 30, 2025? And July 7, 2025? Okay. And you don't have any lawful authority to dispense or deliver that substance, right? You're not a doctor or pharmacist. All right. And did you know that you were breaking the law and violating your probation when you did that? Okay. Mr. Gilbert, you satisfied that action?
I am, Your Honor.
Ms. Goodrich?
Yes.
And Mr. Gilbert, are you aware of any promises, threats, or inducements?
No, Your Honor.
Ms. Goodrich?
No, Your Honor.
All right. Well, Mr. Baker, I find that your plea is knowingly, understandingly, and voluntarily made, and that there is a sufficient basis in fact and law to believe that you have violated your probation. So I'll accept your plea. I think I'll refer it for preparation of a probation violation report and set it for sentencing. Maybe, let's see, if he's being sentenced on April 14th, maybe we'd want to sentence him after that, either the 21st. We just added some of your matters in the afternoon.
Yes, and I would ask him to be assigned to me for sentencing.
Okay. Okay. Yeah. We'll refer it to the Office of Assigned Counsel for appointment of Mr. Gilbert. And let's schedule it for probation violation sentencing on April 21st. I don't know really what the docket looks like that afternoon. We'll just put it at 2:30. Anything further from the defense?
Your Honor, I just asked if he could be released on a PR bond. He's currently on that for Mackinac, and just let the court know this was back in June of last year, and now a lot's happened since then. Mr. Baker's been to rehab, and it looks like he's going to have an extended probation with Mackinac, but what I understand, he's been doing quite well since then, and being for employment at the Kingston Kitchen in St. Agnes. So I'd ask that the court allow him to post a bond in this matter.
So it's a little unusual that there's such a delay, and when we know about this, but is that because it's a function of was this one of the drug enforcement teams? Was it a controlled by situation?
That I don't know.
Ms. Curtis, do you have any knowledge of the Mackinac County matter?
It looks like he was arrested by the Mackinac Island Police Department
Oh, okay.
on January 16th of 2026.
Okay, so nobody knew about this then until this year. What's your position with regard to any release?
Your Honor, I know we're here on a delayed matter, but it doesn't change the fact that within a few months of being put on felony probation for drug-related charges, he's not only possessing drugs, but delivering them 3 times in an adjoining community. He was arrested back on January 16th. We're just now finding out about this in March after he's entered a plea. So those are all concerning things. I would ask that his bond remain revoked until sentencing.
One of the things that worries me, Mr. Baker, is at the initial sentencing, your guidelines range was 34 to 67 months. So it was a prison guideline range, and we gave you a downward departure with a sentence agreement of a county cap to place you on probation. And I don't know if I expressed it to you, but my notes to myself was that I was not super optimistic about your prospects on probation because you'd had some previous problems on probation. When did you go to rehab?
I went, I want to say August 18th. it was after all this. Like I was still using, you know what I mean? Like I wasn't, and since I've been to rehab, I've been doing absolutely great. Like I've been probably doing the best I've ever done in my life, without a doubt. Like my child support's getting paid. That's another, I'm on, case up in Mackinac County for that. Like I've been doing everything since that happened. So rehab changed my life.
Do we have any information about how he's been doing on supervision other than the discharge?
He was on active supervision when they arrested him for us, and he was doing well. This incident was brought up later. There was something going on up there, but I do believe it was a trouble by their undercover team throughout this process. Those charges came later, and then the agent up there just did not notify us until recently. So that's why they came up now. But he was being supervised. They were seeing him. He was recording. There was no noted issues going on.
Mr. Baker, it's definitely a strong possibility we'll be talking about at your sentencing whether you should go to prison on the violation of the probation. But I think there's a few factors that do support leaving our options open at this point with that this happened last summer, that since then the steps you've taken with successfully completing rehab, with maintaining employment and reporting with no other issues. I'm going to allow you to be released on $5,000 personal bond in both these matters, subject to just standard conditions. You're still on probation, so you still have to comply with all the conditions of your probation. But understand, Mr. Baker, that guideline range is pretty wide as well, from like less than 3 years to more than 5 years. And I don't have to follow those guidelines when you violate your probation. So if you cause any trouble between now and the sentencing, or you don't show up for the sentencing, what do you think I'm going to do when we do catch you? Give you about as much as I can, right? So
This second hearing took a completely different turn, and honestly, it shows how much judicial discretion can shape someone's future. Unlike the earlier defendant who remained behind bars, Mr. Baker convinced the court there may still be hope for rehabilitation. The judge acknowledged the seriousness of selling controlled substances while on felony probation, but he also weighed something equally important: post-offense behavior. Rehab completion, stable employment, compliance with supervision, and personal accountability clearly mattered here. But make no mistake, the warning from the bench was crystal clear. The judge essentially told him, one wrong move before sentencing, and prison becomes extremely likely. That's the balancing act courts constantly face: punishment versus rehabilitation. And now we want to hear from you. Do you think the judge made the right call by granting bond, or should repeat probation violations automatically mean jail time? Drop your thoughts in the comments below. And if you found this case as shocking as we did, make sure to hit that like button, share your thoughts, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
you want us to keep our mind open to possibilities, you want to show me that we should. All right, so we'll enter those orders and we'll see you back on April 21st at 2:30 p.m.
Thank you.
Oh, you have to cooperate then with a probation violation report with your agent as well. All right, we'll see you then.
Yes, well.